Testing 1, 2, 3. Testing 1, 2, 3. Testing 1.
Check one. Check one, check two. Check one, check two.
A little bit of reverb on the mics because of the...
Is it too loud?
Testing, 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 testing.
Do you want to turn it back down? Line 2 down a little bit? Line 2, yeah. Do you know how to adjust the gain on this song here? Yeah. Yeah. Oh, I see.
Probably turn down line 2, which is the ambient. I might even go real low with this. I get 2.
One, two, three, four.
I think it's all right. There's a lot of echo. Turn it off for a second. Did I detect
How's the sound?
Go, 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 go.
Check one, check two. Check one, check two. Check one, check one, check two. Check one, check two.
Good morning, everyone. My name is Jim Hartwright. I'm the town manager for the town venue River Shores, Florida. We are here for an initial conflict assessment meeting between the town of Indian River Shores and the city of Vero Beach pursuant to Chapter 164 of Florida statutes. Today's date is October 14th, 2021, and first I want to thank all of our friends at Indian River Charter High School for helping us with this venue. At this time, if we could all rise, face the flag, and we will engage in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Everyone can be seated. At this time, I'll just announce present on behalf of the town of Indian River Shores, Bruce May and Kevin Cox with Holland and Knight, counsel for the town, Pete Sweeney, town attorney, and myself, James Hartwright, town manager. Mr. Falls, if you'd like to go ahead and introduce the personnel on your side.
Thanks, Jim. I'm Monty Falls, the city manager of City of Vero Beach, and our attorney today is our staff attorney, John Turner.
Great, thank you. At this time, I will yield my time, so to speak, and defer to attorney for the town of Indian River Shores, Bruce May.
Thank you, Jim. Good morning. As Jim said, I'm Bruce May with the law firm of Holland and Knight. We represent the town of Indian River Shores. I'm joined this morning by my partner, Kevin Cox. We're meeting this morning as required by Chapter 164 of the Florida statutes. As I understand that statute, we're all here in a staff capacity to provide our respective assessments of the issues in dispute, and then to explore whether there may be a pathway to resolve those issues. We believe the issues in this dispute have been clearly set forth in the complaint which the town filed with the Federal District Court against the city back in August 26th, I think was the date. So in the interest of time this morning, I don't want to spend a lot of time rehashing the arguments and the issues which we believe are spelled out in the town's lawsuit. However, in looking at some of the videos of the previous city council meetings and the previous conflict assessment meetings that the city has had with Indian River County, it appears that the city has some misunderstandings or misconceptions regarding the intent and the substance of the town's lawsuit. So in the spirit of trying to resolve the conflict, I think it would be helpful for me to try to clear up some of those misconceptions this morning, and I'll be very brief. In a nutshell, the town's lawsuit against the city centers around a territorial agreement that the city entered into with the county back in 1989 as part of its franchise agreement with the county. The city appears to take the position that that territorial agreement extends in perpetuity and would forever prevent the town from contracting with the county to provide essential water, wastewater, and reused water services after the town's franchise agreement with the city expires, unless and until the city, in its sole discretion, gives its consent. The town has a fundamental obligation to provide and to furnish its residents with essential water, wastewater, and reuse water services. To fulfill that obligation, the town has entered into a franchise agreement with the city that allows the city to place its utility facilities in the town's rights-of-way and authorizes the city to furnish those essential water, wastewater, and reuse water services to the town and its residents for a limited period of time. The franchise agreement itself has a standard term of 30 years, but the city has agreed that the town has the right to terminate that agreement on its 15th anniversary, which would be on or around October 1st, 2027. The city has also agreed that to what some commentators have referred to as an ouster provision, and that's found in Section 3 of the franchise agreement with the city. And that provision, what that provision means is that on the date the agreement is terminated, the city will no longer furnish water, wastewater, and reuse water services in the town. And essentially, all of the city's utility facilities in the town, with certain limited exceptions, would automatically and immediately become the property of the town. So to ensure a seamless switch in providers on the termination date, the city and the town agreed that the town would notify the city of its intent to terminate the agreement 4 years in advance of the early termination date, so that the town can make other competitive arrangements for the supply of water, wastewater, and reuse water services to its residents. We believe that the city's position that the territorial agreement would forever foreclose the county from providing or offering to provide the town with competitive water, wastewater, and reuse water services after the franchise agreement expires is, by its own terms, anti-competitive and violates the federal antitrust laws. As I said, if the town elects to terminate the franchise agreement on its 15th anniversary, it needs to give notice to the city on or before October 1st, 2023. So it's really only prudent for the town to be looking closely at its options for these essential services now, as we approach that early termination notice date. And it's for that reason, and for that reason alone, that the town filed its lawsuit against the city, for the sole purpose of getting clarity as to its rights under its contract, its rights to contract with others for these competitive essential water, wastewater, and reuse water services. So that's really the impetus of the lawsuit. There are a couple other what appear to be misunderstandings or misconceptions that I'd like to try to briefly clear up. First, the city representatives have said at certain times that the territorial agreements are commonplace and in the electric industry, and they're not restraints on trade. Certainly, territorial agreements are common in the electric industry, but those territorial agreements are approved by the Public Service Commission. The territorial agreement between the city and the county is not. We believe that Florida law is clear. Territorial agreements are horizontal market allocation agreements and are per se violations of the federal antitrust laws unless they are approved and closely regulated by the Florida Public Service Commission or some other supervening state agency. Again, in this case, this territorial agreement between the county and the city is not regulated or overseen by any supervening state agency. Territorial agreements, by their very terms, establish monopoly service areas. And monopoly service areas pose potential for monopoly abuses unless those service areas and those monopoly service areas and territorial agreements are closely regulated by some supervening state agency like the Public Service Commission. The city's non-resident customers in the town and in unincorporated Indian River County are particularly vulnerable to potential monopoly abuses because they are disenfranchised. Non-resident customers have no vote in how the city operates its water, wastewater, or reuse water facilities, or in how the city charges for those essential services. So this territorial agreement between the city and the county is fundamentally different from electric utility territorial agreements. The city and the county territorial agreement is completely unregulated by any supervening state agency. And again, it is because of that we believe it's violative of the antitrust laws. Another misconception is that the city seems to suggest that the town's lawsuit is intended to delay the development of a new wastewater treatment plant that the city is considering. That's simply not correct. Again, the reason the town filed its lawsuit was that in March of this year, Mr. Falls wrote a letter to the county administrator warning the county that the 1989 territorial agreement permanently barred the county from serving the town unless the city, in its sole discretion, consented to that arrangement. The town is not saying, I want to be clear this morning, the town is not saying that it doesn't want to continue to take services from the city. It simply wants to preserve its right under law to consider competitive alternatives, and the county is the most obvious of those alternatives. For the city to try to deprive the town of its right to consider those competitive alternatives is, we believe, by definition, anti-competitive and again violates the antitrust laws. The town's lawsuit shouldn't scuttle the city's consideration of the new wastewater treatment facility. In fact, it should bring clarity as to the appropriate scope and size of that facility the city is to build. Before offering our thoughts regarding a possible resolution to the dispute, I believe the city has also expressed some concern regarding the scope and the structure of the complaint, and Mr. Cox wants to address those particular issues.
Thank you, Mr. Mayor. Just a couple of points on the procedural framework of the complaint and the structure. There was a question about why the suit was filed and then the 164 proceeding proceeded. Based on the way Chapter 164.1041 reads, it does contemplate exactly that sequence. If a governmental entity files suit against another governmental entity, the court proceeding on the suit shall be abated by order of the court until the procedural options of this act have been exhausted. So we're just trying to operate within the constraints of that statute, and we think by filing the complaint, the town believes, but by filing the complaint, it'll help crystallize the issues, and hopefully we can work in good faith to come to a resolution even more efficiently in this process. Another question that has arisen is why the town named the city officials as defendants in the complaint. they are only named in their official capacity, not in their personal or individual capacity. And the reason for that is because we're asking for injunctive relief from the court regarding the issues that Mr. May just described. And the officials who set that policy and implement that policy that we're asking for injunctive relief on are the appropriate people for the court to order, to follow that order that the court, we're asking the court to enter. So that is the only reason. We are willing to further consider if there's any way to further resolve the concerns about that. But again, I want to reiterate, they're only being named in their official capacity of the city.
So that's our assessment of the points in contention. I think under the statute, we were asked and we were directed to think of possible solutions to this conflict. So we would propose the following for purposes of the discussion this morning. We believe that a fair resolution would be for the city to simply confirm that the territorial agreement with the county would not foreclose the county from providing competitive alternative supply options to the town after the franchise agreement between the town and the city expires. This is not to say, as I mentioned earlier, that the town would necessarily take service from the county. If the city is truly confident that its wastewater treatment facilities would be superior to those of the county in terms of price, quality of service, and environmental attributes, then we see no reason why the city should fear allowing the county to provide a competitive proposal to the town. Again, that's all the town is asking for, is to allow competitive forces to work. We believe that would clarify the issue quickly and allow the parties to move forward with their respective municipal functions and duties without any further uncertainty or delay. That's our assessment of the conflicts, and that would be our a high-level structure for a possible resolution. And we look forward to listening to you all and having an open and hopefully productive conversation. Thank you.
Thank you, Mr. May. John Turner for the City of Vero Beach. And as raised by Mr. Cox, I think the first issue I'd like to address is that this complaint that was filed against the City of Vero Beach also named the individuals who are the council members and also named the individual who is a city manager sitting next to me. And it did state in their official capacity, but nonetheless, they were named individually. The council members named and the city manager never signed the 1989 agreement. I think that's clear. Mr. Mayor Brackett, did you sign the 1989 agreement? No, sir. Councilmember McCabe, did you sign the 1989 agreement? No. Councilmember Manous, did you sign the 1889 agreement? No, sir. Councilmember Winger over there, did you sign the 1989 territorial agreement with the county? No, sir. All right, so you've named 5 people. And Mr. Falls, did you sign that agreement?
I didn't work for the city in 1989.
So the answer is no.
No.
So you've named these individuals, had nothing to do with this agreement, but you've named them. You listed them. But you didn't list the other party who did sign the agreement, Indian River County. The only reason I can think of that we discussed about it is the only reason you did that was for intimidation, to try to scare these individuals. Because the law is clear. The suit against the city council members, as well as the city and the city manager, is redundant. There's no need for it. You're going to file a lawsuit against the city, that covers it. The council members are officers of the city. The city manager is an officer and works for the city. He is bound by, and they are bound by, the actions of the court as officers and employees. So all it is being redundant. They should be dismissed with prejudice in this particular case. And the reason is quite simple. Next month, we're going to have an election in the city, and there may be 2 new members on city council. Are they going to be named also now as defendants? Well, that's absurd. There's no reason that they should be continued as a party. And it's cited whether it was an injunction action or declaratory action. It's the same. That's the case with Brandon Woods Homeowners Association versus Mavard Trading, 277 Southern 3rd, 664 Southern DC 8, 2019 case.
Was that a federal court case or a state court case?
May I finish, please? We let you finish. You did not name the indispensable party involved, which is the county. Didn't the county have immunity in this particular case as claimed for an antitrust violation? I think it does. The first key principle I'd like to address in a dispute regarding antitrust laws that you raised is that they were not intended to apply to actions taken by state governments. That's Parker v. Brown, 317 United States 341, 1943 case. The general immunity for state actors acting pursuant to state law applies in antitrust cases. Another key principle relates only to applying state action immunity to municipal ordinances, such as the city. You claim that these ordinances and resolutions adopted by the city are preempted by the antitrust laws in your opening statement. The Supreme Court has clarified and revised this test as it applies to municipal ordinances. That's in the town of Haley, the city of Eau Claire, 1985 case. It says that the first prong requires a clearly articulated and affirmatively expressed state policy of antitrust immunity for municipalities. The prong is satisfied when anti-competitive conduct is a foreseeable result of the state's authorizing statute. The explicit statements by the state legislature that it anticipated anti-competitive effects are not required. The final prong requiring active state supervision of regulatory scheme is not required when the defendant is itself a municipality and not a private actor. So we, by citing the appropriate constitutional provisions of the Florida Constitution, as well as the provisions of state law, state statutes, which authorizes these positions, and the actions taken regarding this territorial agreement, and being supervised by the municipality, it's clear that the immunity applies clearly in this case to the city. All right, aside from this agreement, the territorial agreement from 1889, it wasn't signed by any of the defendants that are named individually. Assuming that agreement doesn't exist, or it expired, or it's terminated, there's still the provision of section 153.031 of the state statutes that the state has stated in its state law that no county shall furnish any of the facilities provided by this chapter to any property already being furnished like facilities by any municipality without the express consent of the council, commission, or body having general legislative authority in the government of such municipality. So what this says is exactly what's provided in the 1989 agreement. You have a city providing services to another city or another municipality, and then the county cannot make that service, provide that service without the consent of that provider. That's state law. So we have the agreement, we don't have a misconception about the agreement. The agreement is perpetual. It's clear, unambiguous. We've gone through that with the county over and over. There's nothing to contradict the language contained in the 1989 agreement about its application. Furthermore, we question the town's standing to really legally or to challenge the legality or the enforceability of the territory agreement. The town has never objected to the agreement. It has received substantial benefits from its application and service provided by the city over the years. We submit that it's allowed the town to prosper and develop. And under section 180.03, subparagraph 2, any objections to such a territorial agreement must be filed within 30 days after the passage of the resolution adopting the service territory. That was not done in this case. The town never objected. It wasn't until recently that the town raised these objections, which we submit are without merit. The antitrust laws are intended to apply to competitive actions in the private sector, not to governmental actions, because it makes sense, particularly in the utilities business, when it takes the amount of money and time and effort to establish an ongoing utility service. That's why you don't see 2 or 3 water meters in your front yard. You see 1 because it's being serviced by a particular utility provider. So I guess from your complaint, what you want is the opportunity for the county to serve you. That's what I gather from your complaint, and I gather from your opening remarks. When under state law, the county cannot serve you without the city's consent. It's that simple, regardless of the 1989 agreement. So I guess what we need to know is, what do you really want? What are you looking for? What's the town looking for in this action? So I guess, Monty, do you have anything you want to add?
Thanks, John. I don't have a whole lot to add other than the town is vulnerable to monopolistic practices by the city, i.e. rates. The state law is clear that rates have to be set that are fair and equitable and that allow the provider to recover the cost of providing those services. It's commonplace for utilities all over the state. It's the same way our counterparts in the county determine their rates here locally as well. I'd like my colleague, if we could find out what the town is really looking for, maybe we can reach a resolution. The city has provided utilities to the town of Indian River Shores. Agreements date back to 1956 and have done so at the request of the town. And those utilities, as Mr. Turner said, have allowed the town to prosper. And we're not saying the town wouldn't have been in the position it's in now without our utilities, but those utilities allowed the town to develop sooner rather than later. I've had the the opportunity as a consultant to work on many projects in the town and have enjoyed that and saw those projects come out of the ground and saw houses be built on them. And it's fulfilling to see that happen. And it was done because utilities were provided. When the wastewater services in the town couldn't accommodate the town came to the city, and the city always accommodated those. History shows that. So if we could get an idea of what it is that you're looking for, maybe we can solve it. Thank you.
Mr. May, anything additional before we move on to number 3, resolution of issues, proposal,
Yeah.
and discussion of settlement?
And I appreciate, John and Monty, I appreciate your remarks. Just a couple of things, and I know Kevin wants to address the officials who were named in the complaint. That's certainly, I think, a sore spot, and we wanted to explain why that was done. But before we get there, Mr. Turner, we fundamentally disagree. In the case of the City of Lafayette v. Louisiana Power and Light, the court has been very clear, the Supreme Court of the United States has been very clear that the antitrust laws do apply to municipalities like the City of Vero Beach. With respect to your argument that somehow Section 153.03 would give the city the perpetual right to be the gatekeeper as to who can provide service to the town, we don't think that's the case. I think you're misreading Section 153.03. That basically says no county shall furnish any of the facilities provided by this chapter to any property already being furnished the facilities. This, as I mentioned in my opening statement, the franchise agreement that the city agreed to with the town of Indian River Shores has what lawyers from other law firms have commented. There's law review articles. It contains what's known as an ouster provision. And there is a flashpoint on the termination date. All of the facilities, the city has agreed to the fact that upon the termination of the franchise agreement, essentially all of the facilities in the town immediately are conveyed and become the property of the town. And the city will no longer be furnishing services to the town at that point in time. So 153.03 would not apply. The city would not be furnishing services at the end of the franchise agreement. Again, we believe that the antitrust laws do apply to the city of Vero Beach. We think the United States Supreme Court decision in the city of Lafayette versus Louisiana Power and Light confirms that. I'll defer to Mr. Cox to again explain why we named the city officials in the complaint.
Yes, and thank you again, Mr. Turner and Mr. Falls, for sharing your perspective, and I think that's what this process is for. Those city officials were not named for purposes of intimidation. When we filed the complaint, we weren't sure what defenses or responses the city may send back our way. And so in abundance of caution, we tried to make sure that we didn't state our claim in a way that would leave a hole if we were to obtain or sought injunctive relief, that the appropriate parties were named who could provide that and follow that order for injunctive relief. Hearing your analysis and view of the issues here, we disagree, as Mr. May said, that the city is entitled to any sort of immunity as the state. As Mr.
I'm sorry, I didn't mean to interrupt.
As Mr. May said, the city of Lafayette case, I think, is very clear on that. And you mentioned the Parker case. Lafayette quoted the Parker case. It said, therefore, in the absence of evidence that the state authorized or directed a given municipality to act as it did, the actions of a particular city hardly can be found to be pursuant to the state's command or to be restraints that the state as a sovereign imposed. And so that's the fundamental distinction I think we are seeing in our respective positions. So we do disagree that the city is entitled to immunity as a sovereign, as the state, whether any form of such immunity. But if that's the city's position, then I think we made the right choice to name those city officials, because that is exactly why in a federal court action, I know you mentioned a state court action, in a federal court action, we do need to name those officials in order to get the relief that we're seeking. So again, we're willing to further discuss that issue with you, but I mean, if that is the city's position, then dismissing those individual city officials would certainly compromise our claims, and we don't want to do that.
Anything further, Mr. May? Mr. Cox?
I think that, I mean, again, I think we just fundamentally disagree on the application of section 153.03. We fundamentally disagree that the antitrust laws of the United States of America don't apply to municipalities, and that we think we have a reasonable, implausible, and in fact, an effective position that we had to name the city council members and Mr. Falls. Again, this is nothing personal here. It's a technical issue that we wanted to make sure that we had the right parties named, and that we had structured our complaint in a way that would avoid the state action immunity defense that Mr. Turner has asserted or suggested that you all will be raising. So, for that reason and for that reason alone, we feel like it's very important for us to name the individuals in their official capacity, not in their individual capacity, but in their official capacity. And to the extent there are elections and new people who are brought on, then those people would be brought into the case for that same very reason. Again, this is not personal. It wasn't done for intimidation. It was done to protect our claim and allow us to sustain our claim through the federal court process. Again, but the fact that Mr. Turner has said that you all will be raising the state action, I mean, that's what we anticipated, and that's the reason why we named those folks in their official capacity. Nothing personal, but just in their official capacity.
And when Mr. May says they would be we just envision, just as in any other case, it's very common, you would just substitute in if there's a new person in that position, because these are the people, even if they didn't sign the agreement, these are the people who are raising this issue and taking the position that the city is going to follow that as a permanent service allocation. That's our understanding of the city's position. That's understanding of the position that these officials are taking. If there's a new official that's substituted in, we can do that. But that's the purpose, not to intimidate.
Well, we interpret it as an intimidation because we feel that it is a redundant action taken because you've named the city. That's the proper party if you want to bring an action for declaratory judgment or injunctive relief in federal court as well as in state court. There are cases in which the official capacity representatives are named in federal cases, but there are also cases in which it has been determined that that is improper, and particularly in a case such as this, interpretation of a territorial agreement. So we're asking you to dismiss those out, and I think that would be most appropriate, and proceed against the city in its capacity as a municipality. I guess you're not going to do it, so we can move on to any other discussions.
Well, I guess
we respectfully disagree with your interpretation and application of Parker and in Halley versus Eau Claire, that the municipality in this case, the city does have immunity, and the antitrust laws do not preempt these many statements of authorization and empowerment by the state for the city to operate its utility services and to enter into such agreements. So we're at an impasse as far as I'm concerned on that question. Now, the issue I want to get back to what Monty said was, what do you really want? What is it you're looking for? I think that would help us and give us some direction. It's just, I don't know. I'll let you respond.
Again, as I said in my opening statement, I think what the town of Indian River Shores believes is that under its franchise agreement with the city, there is express recognition that upon the termination date of the franchise, the city will no longer be furnishing water, wastewater, and reuse services to the town of Indian River Shores and its residents. And it also recognizing that ouster provision, if you will, in Section 3 of the franchise agreement. The franchise agreement also gives a 4-year lead time for the town of Indian River Shores to start evaluating competitive alternatives for the supply of these essential services. So what we're looking for is for the town to have the ability to start talking with alternative suppliers and providers of these essential services. And the county is the most obvious. If the city is taking the position that the county is off limits, the county can never serve, then we again believe that that's a restraint of competition, which is in fact is a violation of the antitrust laws. And that's again the purpose and the real reason we filed the lawsuit is we need clarity on that issue because the 4-year early notice date is October 1, 2023, on or about. That's less than 2 years away. So again, we need clarity, and that's why we suggested as a possible resolution is if the city is confident that its new wastewater treatment plant that it is considering building is going to be superior to any other competitive alternative in terms of price, environmental attributes, and quality of service, then I guess we're scratching our head. Why wouldn't the city, agree for us to look at other options? If you're confident that that is the best and most superior option, then that's what we're looking for. Is really an opportunity to exercise our rights to evaluate other competitive alternatives at this time.
In full disclosure, I think I'm the only person at these two tables that's not an attorney, so I won't try to get into the law. I'm going to just talk about utilities for a few minutes. The city's never said that the county can't serve. Never said that. We were merely pointing out to the county, in my letter that you referenced earlier, an agreement that we had signed with the county, and we feel confident that that agreement still stands. So we were making sure that the county had that knowledge before they went so far as to have those discussions with us. We also need clarity. We're going to build a new wastewater treatment plant. It's going to cost in the $50 million range. It's a big investment. We need to know who our customers are. You build a wastewater plant knowing what flow it's going to have to treat. The Shores represents about 16% of our service territory, our capacity. And we want to build a wastewater plant that will serve our service territory. And we are confident that the plant we build and the quality of its treatment and the pricing for that will be competitive for like services. But as I drove in the parking lot today, I drove in a pickup truck, and I saw some really nice cars in the parking lot. They're both transportation, but they're different in their methods of providing that. So the plant that we're going to build will be a state-of-the-art advanced wastewater treatment plant, which will be the most beneficial thing done for the Indian River Lagoon in this county ever. And I think that's what we've all agreed is our ultimate goal. Not who serves who and at what rate, but let's do what we can to clean up our most valuable natural resource.
Anything further on behalf of the city?
Guess that's it.
Okay. Anything further, gentlemen? I'd just like to just procedurally segue, and it seems that we've gone into Section 3 on the agenda. There had been some discussions initially about the town's proposal for settlement and some additional discussions for settlement. Mr. Turner indicated that he believed that there was an impasse about the council member issue, and Mr. May had preliminarily during his discussions proffered a framework for a settlement. So if there is no agreement on any of those issues at this point in time, and there's nothing further with the parties, then perhaps it would be beneficial for us to pass across some potential dates for a joint public meeting for the council and discuss that topic as we speak.
Okay.
I did have one question.
Sure.
Monty, you indicated that the city would not object to the town talking with the county about possibly providing a competitive alternative to the.
I think my letter that you cited was clear, that if the county wished to serve the town, to contact us and we'd talk about it. I'm still waiting on that.
I guess the elephant in the room is, would the city, and maybe this is not of a discussion for today, but I guess one of the questions that I keep coming back to is, will the city consent to the county providing service to the town at the end of the town's franchise agreement with the city?
I think we've had some discussions in public about that. We haven't made a formal recommendation. We'll be discussing that at upcoming council meetings.
Okay.
But I agree that this is probably not the forum for that today.
I guess just a couple of things to close, because it looks as if we're kind of, as Mr. Turner said, we're at an impasse on the legal positions. But I do think that from our perspective, that as I listen to you, Monty, and Mr. Turner, that it's clear to me the town and the city needs certainty here, needs some clarity. The town needs clarity within the next 2 years, because of this early termination notice date. The city needs clarity. I'm assuming the city needs clarity as to what the town intends to do and what the town can do in order to properly size and to structure and design its wastewater treatment plant. So again, I go back to our proposal that if the city is confident that it can compete with any other proposal and is superior in quality, environmental attributes, and price, then why wouldn't the city just allow recognize that this service territory agreement wouldn't prevent the county from providing these services, and then and allow the parties, the competing parties, to present their competing proposals, and the town could move forward at that, so that no one's would be. We could clearly resolve those uncertainties if we move down that path from our perspective.
Well, we have other issues also with that, in that we not only serve the town, but we serve South Beach, which is another part of the island under that agreement that we've been serving for a while. And so that's going to have to factor into it if we go to that direction, which I'm not saying we will, but there's a discussion on it. And
well,
if we had assets, again, that were maybe part of the equation, that needs to be considered. So that there's a lot of parts to it.
And waiting until, and you brought it up, Bruce, and waiting for 2 years to get an answer to the question from the town. The territorial agreement in Chapter 153, we feel confident gives us what we need to start working on our plan. But if we're not gonna agree to that, we're now 2 years away from the town telling us what their intent is when the 15-year clause is up in the contract. We've been trying to react to what we thought was the public's outcry to move, I'm not gonna say move, that's wrong, to construct a new wastewater plant and then decommission the one that's located on the banks of the river. We want to do that as soon as we can. We have to know what capacity to design for.
and I guess, can I respond?
Sure.
I guess, and I hear what you're saying. I think the structure of the resolution that I tried to lay out, I think it would provide that clarity sooner. I mean, if the city were to say, okay, you know, here's our proposal, county, what's your proposal? And the town could say, okay, you know, the town may agree that the city's proposal is superior, but we don't know. And we would like the opportunity, which we think the contract envisions, in the town being given the time to evaluate competitive alternatives. So
We've also been assured by the county that they have no intent or desire to serve the town.
And
So the option there is up to them if that opportunity occurred. And they have told us on several occasions they have no interest in serving the town.
And we've done the best we can to date to let everyone in our service territory know what the impact of building this new plant is going to be. We've had some preliminary analysis done, and it's published, it's been talked about in public, what we think the rates will do over the next 10 years. I don't know that the county has done that yet. I don't know what their plans are in their future plans for upgrading the plants to meet the same requirements that we're going to meet. So we've tried to be open and transparent and get that information out to the public and to the town and to the county so that everyone knows what we think, with the best information we have in our hands today, is what this new plant is going to be. And that information is $17.66 a month. Added on top to an average bill of $55, you're less than $75 a month for essential services of water and sewer, with the highest treatment capacity in this part of Florida.
Okay.
But, and I appreciate those remarks. From my perspective, there appears to be a real fundamental disagreement on the legal issues and the positions that we've taken in the court case. I think our obligation under 164 was try to explore possible pathways to resolution. I think we've reached that point, as John said. I think we've probably reached an impasse on our dispute over the legal issues.
We'll just need, if I might, I know we have a period of time to set up the next phase, and so we'll just need to try to exchange some dates.
Yeah, like you said, we want to move quickly. We want resolution. We want clarity. So why don't we just get our calendars out now? We'll come up with some dates for the next joint public meeting to get that scheduled, because I think that's the next step in the 164 process.
And we are also want to see a quick resolution of this, and we want to proceed because we need that clarity.
Yep. Okay. So we proposed some dates to Gary.
If you could, I don't have those with me.
Kevin, you want to?
We had proposed November 2nd, anytime, or
That's an election day, that will not be.
we also proposed, well, I apologize then, that we were obviously a lot of moving pieces. We'd also proposed the morning of November 8th and the morning of November 9th.
We'll see who's available and get back with you as soon as we can then. Okay?
Just a quick question. Is there any time frame associated with you advising on the 8th or the 9th, understanding that the 2nd is an election day? And I only say that so that, we can get our council members focused on those days or not. Is it
Jim,
like?
we'll get back with you as soon as we can.
Okay.
All right?
And as I understand it,
We have 50 days. I think we have a time frame.
well, we're under a little bit of a clock that we need to do this. The time frames under 164, we can mutually agree to move
Yes,
them. But
I understand both of us are trying to get this to the issue and resolution as soon as we can, and that's
Yep.
what we're going to be working for.
and just so I'm sorry.
We're not putting this off till the next year or anything like that.
But what I just wanted to, for us to get clarity on what the next meeting would be. It's our understanding, reading 164, the next meeting will elevate from the staff level, and it would be a joint meeting of the elected officials of
Yeah.
Indian River County, Indian River Shores in the city. Okay.
Okay.
And the only final thing is, if for some reason, those dates are not available, or could you just give us at least 2 or 3 more as we
will.
as we move forward, so we can consider those and so
Absolutely
on.
do.
Anything else, Mr. Falls, Mr. Turner?
I think that's it.
Okay, anything else, Mr. May?
I just want to thank you all for
Thank you.
taking time this morning. Thank you.
Yeah, finally, just prior to close of the meeting, I'd like to indicate that we are going to close this
Are we
meeting.
going to have any public comment?
I don't think the statute provides for public comment, notwithstanding the nature of the meeting.
Members of the public other than Dylan Reingold back there.
It's always a pleasure to hear from Mr. Reingold, but since he is deferring,
We'll be here the rest of the morning. if we have to-
importantly, I again want to thank Charter High School, Mr. Ho and
Yes.
his team, and thank you very much. It's very appreciative that
Always a pleasure.
you open it up, and with that, we'll call the meeting to a close. Thank you all very
Thank
much.
y'all. Thank you.
So